Thank you for having me. So, the Federal Competition and Consumer Protection Act 2018 was established against the backdrop of the shortfalls and inadequacies that was inherent or that was hitherto inherent in the defunct Consumer Protection Council, CPC. There was need for a more vibrant and an all-encompassing legislature to cater for the ever-changing commercial space and also for more protection for consumers. Now, two distinct and very important institutions were established under that act. The first being the Federal Competition and Consumer Protection Commission, which is the enforcement arm of the act, and second is the tribunal, which is the adjudicatory arm of the act. Now, by establishment, Section 39, which establishes the tribunal, stipulates or provides that the tribunal shall adjudicate over conducts prohibited under this act and is underlined, and exercise the jurisdiction, powers, and authority conferred on it under this act or any other establishment. Now, the tribunal is composed of a chairman who shall be a legal practitioner with 10 years post-call experience or requisite experience in the field of competition, consumer protection, or commercial and industrial law. Now, this chairman has 6 other members comprising 6 other members representing each of the 6 geopolitical zones. With at least each member must have at least 10 years professional experience in any one or more of the following educational fields: competition and consumer protection law, commerce and industry, public affairs, economics, finance, or business administration or management. Thank you. Section 39 that I just that I just talked about is the primary sets out the primary and original jurisdiction of the tribunal, while going further in section 47 of the same act gave the tribunal additional jurisdiction to adjudicate or sit on appellate position to hear and determine complaints coming from the Federal Competition and Consumer Protection Commission or any other specific sector regulator. Thank you. An aggrieved consumer has some basic options to follow or to explore whenever he needs redress. And such options are contained in section 146, sub 1 and 2 of the Act. So I want to take us one after the other of the options that are, open for the consumer, if I may.
You're permitted, please go on.
Yes, so section 146 sub 1 stipulates that a consumer may seek to enforce his rights under this act, a transaction or agreement, or otherwise resolve any dispute with an undertaking that supplied the goods or services to the consumer by A, referring the matter directly to the undertaking that supplied the goods or services. B, referring the matter to the applicable sector regulator. C, filing direct complaint with the commission, that is the Federal Competition and Consumer Protection Commission, And there is a subsection under that section, subsection 2, which stipulates that notwithstanding the provisions of subsection 1, an aggrieved consumer can directly approach a court with appropriate jurisdiction to seek redress, just like a court like the tribunal. So you or any consumer in Nigeria can directly approach this tribunal to seek redress for any infractions under the Act. Yes, specific sector regulator in this case means, for instance, in power generation, a consumer can directly approach the Nigeria Electricity Regulatory Commission for power or electricity. When it comes to maybe communications, you can approach NCC, which is the sector regulator. Banking, CBN is the sector regulator. NAFDAC is the sector regulator of any food and beverage and any other, I think, medicine, and so on and so forth. Okay, briefly, briefly, the complainant initiated and instructed the defendant to transfer the sum of 500,000 naira from his account domiciled with the defendant to another account on the 8th of September 2022 for the payment of his children's school fees. He claimed that as soon as he initiated or instructed the bank, promptly and instantly he was debited with the sum of 500,000 naira. But incidentally, or however, the amount did not, he didn't get value of same to his account that he instructed to be transferred. So he went to the bank. After some hours, he went to the bank and registered his complaint. And the bank told him, or the defendant told him, that they are doing whatever they could to, transfer the money. So after about 24 hours without getting value, he went to the bank the next day, that's on the 9th of September 2022, when he couldn't get the value, and initiated, let me rephrase. After 24 hours, the amount was refunded back to his account. So he went the next day, being the 9th of September 2022, to initiate another transaction, same transaction of 500,000 naira. Still, he couldn't get value for the amount. So after much complaint, and he couldn't get the needed attention from the bank, he then approached this honorable tribunal for redress. It will interest you to know that it has been 24 to 72 hours after he instructed his bank to carry out that transaction. And going by the CBN regulation, the CBN regulation on interbank, instant transfer, Section 5 sub 2 of the CBN regulation on instant interbank electronics funds transfer mandates a bank to A, refund into the customer's account full proceeds of failed transactions returned by the receiving entity within 10 minutes And B, return into customer's account full proceeds of transaction which the sending entity is unable to process within an hour after the next settlement closure. So from these facts, you would agree with me that there was a lapse of between 24 to 27 hours within which the refund was made, which was in violation of the defendant's specific sector regulator. So it was based on these infractions that the complainant approached the Honorable Tribunal for redress, citing 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 negligence on the part of the defendant, that there exists a fiduciary duty, a fiduciary relationship between the complainant and the defendant, which fiduciary duty or duty of care was not met. Hence, the complainant approaching the Honorable Tribunal for redress. First of all, before I answer that question, I want to comment on a very important provision of the FCCPA 2018 under Section 47. Under Section 47, it said, under Section 130 sub 1A and B, because that's actually the provision, the section that was violated according to the verdict of the tribunal. That's the main provision that, or infraction, that the defendant violated. The section stipulates that a consumer has a right to the timely performance and completion of those services and timely notice of any unavoidable delay in the performance of the service. And B, performance of the services in a manner and quality that a reasonable person are entitled to. So you see, this particular provision is probably the most important, when it comes to consumer rights in this country. So as to your question, well, basically, after the tribunal has given its verdict or judgment, the registration and enforcement of such judgment will now, like under Section 54 of the Act, which stipulates that an order, ruling, award, or judgment of the tribunal shall be binding on the parties before the tribunal and be registered with the Federal High Court for the purpose of enforcement only. So basically, after the tribunal becomes functus officio, after making its ruling or awarding any fine, or awarding making an order, making any ruling, or making any award or judgment, such judgment will now go back to the Federal High Court for enforcement only. Yes, I think the basic option, if a consumer might or would like to explore, is the option contained in Section 146 sub 2, which gave a consumer the right, or an aggrieved consumer the right, to directly approach the tribunal for redress. That's the best option the tribunal can give.
Looking to still come back to the issue of Stanbic IBTC, it does appear that that's fine imposed on the bank looks like the biggest fine thus far that the tribunal has imposed on any entity since its formation by law by
Yes.
the Act of 2018. Would
Yes.
be correct?
Yes, you are quite correct, sir. You are quite correct. Because it's within the powers of the tribunal to fine any entity or individual of a sum not more than 100 million or 10% of the entity's annual turnover, whichever comes first. So it's within the rights, powers, and jurisdiction of the tribunal to fine any entity of a sum not more than 100 million. It could go up, but nothing less, not less than 100 million. So the tribunal is within its powers to make such fine. The FCC, especially the tribunal drives its powers not only from the FCCPA 2018, but rather it drives its powers also from the Constitution, that is the ground norm of the Federal Republic of Nigeria, under Section 4, Sub 8 of the Constitution, which stipulates that safe as otherwise provided by this Constitution, the exercise of legislative powers by the National Assembly or by a state house of assembly shall be subject to the jurisdictions of the courts of law and of judicial tribunals established by law. And accordingly, the National Assembly or a house of assembly shall not oust any law that shall not oust or propose to oust the jurisdiction of a court of law or of a tribunal established by law. So basically, the FCCPA is not, it drives its powers directly from the ground norm, that is the tribunal. It's not subservient to any other legislature duly passed by the National Assembly or States House of Assembly. It's the only law that is empowered to adjudicate on matters pertaining to competition and consumer rights throughout the country. There is another legislation, the BOFIA, Banks and Other Financial Institutions Act, which stipulates in one of its provisions that the provisions of the Federal Competition and Consumer Protection Act shall not underline, according to the BOFIA Act, shall not apply to any bank or any transaction, that comes out from a bank. So having said that, and from the constitutional provision that I've just explained to you, you can see that BOFIA Act is a legislation passed by the National Assembly. So since it's a legislation passed by the National Assembly, it cannot oust or purport to oust the powers and jurisdiction of the Federal Competition and Consumer Protection Act, by virtue of Section 4, Sub 8 of the 1999 Constitution as amended. So basically, the FCCPA 2018 is the highest legislation to, regulate and direct any matter pertaining to competition law, to competition and consumer protection in the country.